Me and that printer. Me.
going to call to order this meeting of the House Judiciary Committee. And I appreciate everyone being with us today. If you would, as we always and traditionally do, bow your heads, and we'll begin this meeting with a word of prayer. Lord, we pause as we always do to thank you for this day. We ask you to give us the wisdom now as we sit as this House Judiciary Committee to do what is best for the people of this state. Amen. All right. Ladies and gentlemen, we had a Scrivener's error in a bill that was passed out earlier. If you look in your folder, House Bill 296, there were two words transposed, I guess we would say, and that made a difference. Do y'all have a copy of House Bill 296 in your folder? Let's see if I have one. Okay. That's it. If you will look on line 11, after Hall County, the word second was mistakenly put as first. And then further on that line, right before Monday, the word first was mistakenly put as second, which you can see would change things. So this morning we recommitted this bill back to Judiciary to switch those two words on line 11, the word second and the word first, which made it how the judges in that circuit wanted it. Any questions about what I've just explained? Any questions? If there are none, with that simple fix, Mr. Welch?
Motion to recommend do pass.
Okay. Is there a second? Any discussion? Motion is to pass by committee substitute House Bill 296. If there is no discussion, all those in favor say aye.
Aye.
Any opposed? And we have now corrected that little Scrivener's error. Thank you very much. Now, Mr. Welch, we have one bill for you, but we're waiting on some copies. Is that correct, or you do want to go ahead and start it?
I think is there a few that we're waiting on copies?
They're being made right now.
Okay.
Do we need to wait on those?
I can do a general overview
Okay.
right now
All right.
while we're waiting.
Well, let's go ahead then, and we will call up House Bill 311. Chairman Welch.
Thank you, Mr. Chairman. Members of the committee, it is a privilege to present House Bill 311 to you again. This is our constant battle to open up the courts for causes of action that sound in declaratory relief and injunctive relief for our citizens of the state, whereby the state officials, state agencies, or local governments may be acting in contravention to the Constitution, the statutes of the Constitution of the state of Georgia, the Constitution of the United States, as well as state statute, or in the case of local governments, in contravention of rules and regulations in addition to those others. And with this legislation, we've tried to very narrowly tailor the scope of the waiver of sovereign immunity. As members of the committee are fully aware, sovereign immunity is the premise that the king can do no wrong. And so in that context, our as a 13th colony, part of our reason for seeking rebellion against the King of England was because we believed the king did do wrong. And there was no legitimate redress other than to revolt against the mother country of England. Now, in that context, the state of Georgia adopted a constitution that did not provide for sovereign immunity. And as a result, up until 1991, our state constitution was devoid of the protection of sovereign immunity, and thus citizens could bring actions against the state or state actors to challenge their action as being, whether it was constitutional, statutorily authorized, or just generally ultra vires. Since that time, an amendment was adopted by the people of the state of Georgia imposing a statewide immunity provision, sovereign immunity provision, that may only be waived by the General Assembly. And so in that context, it's important that the Constitution now provides, after 1991, that only the General Assembly can determine when sovereign immunity is waived. In other words, when a citizen can petition for redress in the courts of this state. So we hold the keys, and we hold the keys to the courthouse door as to some of those questions. And so this bill allows for an opening of those courthouse doors as to constitutional questions and questions of authority and whether or not individuals are maybe acting outside the scope of their authority. We have worked long and hard in subcommittee, holding at least 3 hearings on this matter, on this legislation. The legislation was previously vetted by the subcommittees and full committees of this Judiciary Committee last year and the session before that. So what I have before you is a substitute to House Bill 311 with changes made in the language of this bill to take into consideration the comments and testimony provided by members of ACCG, representatives of ACCG and GMA, as well as our Attorney General's office. And you will get a copy of an amendment that I have proposed that shows the latest changes that I've worked out and negotiated with the Attorney General. Well, not negotiated, but suggestions that I have weighed with the Attorney General's office on this legislation, taking into consideration the commission that was formed in order to review sovereign immunity in the wake of the Lathrop versus Deal decision. And so those issues that amendment we passed out shortly for you to consider. So, Mr. Chairman, with that overview, I'd be happy to talk to any specific provisions of the legislation as well as to listen to any testimony that may be provided.
So Chairman Welch, we have those amendments ready. Would you like them passed out now?
Yes, please.
I don't anticipate we'll talk about them right this second, but we can go ahead and pass them out. That would be fine. So Chairman Welch, as I understand this very simple issue, everything was fine in Georgia in this area, somewhat complicated but settled until a Supreme Court ruling, correct?
That's correct.
That ruling came 2 or 3 years ago now?
Yes, sir, and then
A couple of them.
a couple of rulings, yes, sir.
Mm-hmm. And so the attempt of this legislation is to begin, and I use the word begin, to put the law back to some extent of what it was before those 2 Georgia Supreme Court rulings that basically made it much more difficult to bring an action against a government entity.
That's
Is that correct?
Yes. Yes,
Okay.
sir.
So, and what you have crafted here is going to affect state government and local government, right?
That is correct.
Okay. All right. I may have some more questions, but let's stop and see if other members of the committee at this time have any comments or questions for the author of the bill. All right. Press your button there, Ms. Silcox, and we'll turn your mic on. There you go.
So, Chairman Welch, I'm just curious because it looks like this 46 through 56. What are the differences on this amendment?
That's a very good question. That is a very good question, Chairman. In looking back through the APA and in discussions with our Solicitor General, the APA, and mind you, I'll say this clearly, that it is not a blanket that covers all edges of the bed here. So we're not covering everything, but the APA currently allows for you to bring declaratory relief and seek a stay as to the implementation of a rule or regulation as defined by the APA, which is a very broad definition. It's not as broad as we discussed in subcommittee, as
Correct.
we looked at before,
Mm-hmm.
but it would be any rule that has the force and effect of law. The AP allows for you to challenge that, and also allows you to challenge whether or not the rule or reg was adopted pursuant to in accordance with state law, in other words, had the proper authority, or the Constitution. So in that context, there is a current process by which citizens can appeal a rule or regulation in how it was prepared, adopted, the process, as well as whether or not it was ultra-virus to a statute, lacking the statutory authority. With that in mind, I have excluded the rules and regulations from the provision in lines 46 through 56. So that there's no longer a reference to rules and regs there.
Okay.
And part of the concern was that in opening up the waiver provision, there was heavy concern, I think, both in the subcommittee and with the Solicitor General and the AG, that we may be opening up a door that previously didn't exist, and also so we'll be widening the scope of a waiver of sovereign immunity beyond what we had previously understood. But more importantly, there may be aspects that interfere with the contractual relations that may be that state agencies may enter into, and may create litigation in order to delay contracts or to further undermine contracts that are essential to governmental functions.
Okay.
Erring on the side of caution and moving as closely as I could to what we understood the law to be, we revised this language in the proposed Welch Amendment, revises that language 46 through 56, those lines, to be a much more narrow statement of what the waiver will be as to the state. And in summary, it does not include rules and regulations or policies or contracts that may that may be subsequent to that may fall under that purview of rules and regulations.
Thank you.
That is not true. However, I will state that while we're on this point, that local ordinances that may be adopted or policies or procedures that may be adopted by a political subdivision, however, those would still be those would be subordinate to those rules and regulations, and therefore we do have a definition for rules and regulations in the local government article of this bill, Article 2, and that those ordinances are subject to a challenge should they be deemed to be contrary to a rule or regulation of the state.
Thank you, Mr. Chairman. I want to thank Chairman Welch for the immense amount of work that he's done on this bill. I was on the Court Reform Commission, so I've been involved in this effort to cure what is a very significant problem exists in the law at this time for some time. But I'm very disappointed that the APA provisions have been taken out of this bill. I mean, I've used this example before for those of you that weren't in these many subcommittees that we held. And we talked about this specifically. The provision that came out of the subcommittee, and please correct me if I'm wrong, was that a Georgia citizen would have the right to get injunctive or declaratory relief for a rule or regulation enacted by a state agency pursuant to the APA. I thought that was fairly narrow, but it did allow some opportunity for citizens to look at Administrative Procedure Act violations of law. The example that I kept coming back to was the lawsuit that was brought last year against the Georgia Building Authority that had a written guideline that said you were not entitled to a permit to demonstrate or to assemble on Liberty Plaza unless you were quote unquote invited by a constitutional officer. Clearly, that was a clear constitutional violation, clear violation of the Georgia Building Authority's implementation of its authority over Liberty Plaza. And I never could get an answer whether or not that guideline was passed pursuant to the APA or not. So I don't know whether it was covered on the last rule, but clearly it's not going to be a citizen who's denied a permit to demonstrate across the street based on a guideline or a rule or regulation. I do not believe is allowed to bring an action for declaratory injunctive relief under this fix. Tell me if I'm wrong, please, sir.
It's a very good question, and I have immense respect for Representative Oliver. The answer to her question is no. This would not provide that avenue. It is not my recollection of the Commission's recommendation, however, that we were supposed to open up that aspect.
That's true.
I know that the representative wants us to.
Right,
And
and I
I-
think that was a debate in the commission. And I think that we, throughout this long process, have had a fair and open debate about, can citizens sue for violations of law or rights? And clearly this step that we're taking here is fairly narrowly drawn and even more narrow than the subcommittee considered.
It is more narrow than the subcommittee considered, and I think that, so having challenged this, having filed a challenge once myself as well, to what was purported to be something adopted pursuant to rule, required to be adopted pursuant to rule and pursuant to the APA, turned out it was not. And having successfully challenged that myself, I do know that the APA works. In other words, I know that it works if you have an item that should have been adopted by rule in order to have the force and effect of law, and it was not adopted by rule or regulation pursuant to the APA, it is void and can be challenged for declaratory relief. I'm not sure that it solves every single situation, but I do know that I've had success in that sense. And so I commend to the committee that the point of this is, does the public have an avenue by which to challenge an agency action? And the answer to that question is yes. And what this legislation would do, and specifically the amendment that you have before you, it would allow for those that have been harmed by an employee, by an agency, by the state. You can seek that declaratory or injunctive relief as a remedy to the injury in fact that's caused to such an aggrieved person. And in that includes the imminent threat of injury by the state, by state governmental entity, by an officer or employee that is in violation of state law, the Constitution of Georgia, or the Constitution of the United States. It is more narrow than the subcommittee considered because of the rule and reg deletion. However, it still provides an opportunity for citizens to sue that currently does not exist. We are moving the ball towards opening up the courthouse doors, maybe not as wide as we'd once hoped for in subcommittee, but I think in full committee, this is a very good step to opening up those doors to address the most egregious types of abuses, which would be abuse of state law, the constitutions.
Forgive me, may I go back to which amendment we're going through? One is 48 through 65, and the other is 46 through 56.
It's LC 41-19-29S.
Okay.
So that was Jordan was trying to do me a favor and get it quickly done, and the final sub came out. So the one that we're considering, the Welch amendment, is to 41-19-29S, and that's the bill that I'm recommending to the committee, noting that that is the most significant change. The rest of the language changes were edits, clarifications, and comments that I'd received, making sure that we understood that the waiver of sovereign immunity was supposed to be limited, and that the suits to be brought were specifically brought pursuant to this new code section if it ever gets, this new article if it ever gets adopted. In addition, you'll see on that same amendment that we've added a clarifying statement that would come after what I call the yo-yo provision, which is the last provision of your bill under section 4-1. And this is language that would allow for an appeal, interlocutory appeal, during the proceeding of the case, but it only allows for that to occur once during the proceedings of a case, so that the government cannot claim one immunity, seek an appeal on it in the middle of the case, and then once that decision is made, raise another immunity in the middle of the case, take it up on appeal, thereby essentially driving up litigation cost using immunities as a tactic. So this would now require it all to be brought interlocutory one time, but adding the sentence in your amendment, you'll see that this is intended so that it does not preclude the government from raising that same issue of immunities on appeal at the final conclusion of the case. So you have one shot interlocutory, one shot while the case is going on, and then one shot at the end of the case after you've had a final judgment.
May I ask one, if I may ask Chairman Welch, I don't remember discussing our implementation date. Why did you put this out for a year? I'm looking at line 283.
Oh, I'm happy to make it effective sooner. I'm sorry that was.
I just didn't know if there was a reason there.
I think
Gary,
it's.
you wanna say something?
That was at a request of Andrew.
Who's Andrew?
He's
I
our
think his last
Solicitor General.
name-
Solicitor
General. Sorry.
No, I'm fine. I'm fine. I'm fine with making a change to that to make it effective, just deleting it altogether. But no, the intention was there to, from my perspective, was to make it effective as soon as the governor signed it.
Other questions of the author of the bill? Okay. Do we have anyone signed up then who would like to speak to the bill? If there is a sign-up sheet. Is there? Oh, here we go right here. My bad. All right. Thomas Weaver. Thomas, you want to come up? Good to see you today.
Thank you, Chairman.
Good to have you. Please introduce yourself, and we'd be happy to hear from you.
Yes, sir. Thank you, Chairman Fleming, members of the House Judiciary Civil Committee. My name is Thomas Weaver. I'm a private citizen, and I rise before you today in that capacity only. I'm very grateful for the efforts of Representative Welch, or Chairman Welch, to bring this measure, and I'm very cautiously hopeful and optimistic that this Judiciary Civil Committee grant due passage recommendation so that this measure can move to Rules Committee. I have to say that I'm a little dismayed to learn of some of the concessions that have been made in the subcommittee as to where the bill started when it was originally introduced until now. But something is certainly better than nothing. It's not about using the state or any local governmental unit as cash cow. Some things are bigger than money, and the ability of a person to bring a declaratory or injunctive relief civil action to address and to stop local governmental units from causing additional harms by violating fundamental constitutional rights or statutory privileges retained by the citizens of the state is extraordinarily valuable to me and others, and I think that this is something that this House and this Camera and this committee is uniquely situated today to address. In listening to some of the comments that have been made by Representative Mary Margaret Oliver in conversations with Chairman Welch and others, it would be nice if this would be inclusive of the Georgia Administrative Procedures Act. You know, the commissioners that are assigned to head the various different departments of the executive branch and the boards that you create through state statute. You know, they do make rules and regulations that do get placed into the Georgia Administrative Code, which is separate than the official code of Georgia annotated. It's not state statutes, just rules and regulations. It would be nice if this would encompass that. Unfortunately, it doesn't. It would be nice if this would encompass school districts. Unfortunately, this does not. There are certain things here that unfortunately must be left out, but something, again, is better than nothing, and it's my hope sincerely that this measure in its current form can gain traction today. Thank you, Chairman.
Thank you, Mr. Weaver. Any questions for our witness? Okay. Thank you very much for being here today. We appreciate you coming. Okay. Next we have Bill Clark. Mr. Clark, tell us who you are and who you're with.
Thank you, Mr. Chairman. Bill Clark on behalf of the Georgia Trial Lawyers Association. Because particularly the subcommittee members have heard more than enough of me on this issue, I'll be very brief. But thank you to the subcommittee members because, as Chairman Welch indicated, y'all have spent hours and hours chewing through this. This goes back to the 2014 decision of Sustainable Coast versus DNR, in which the Department of Natural Resources broke the law, or at least violated their own rules and regs, as to how to issue a variance from the permitting process. In other words, somebody wanted to develop protected wetlands, and the department, violating their own rules and regs, issued a variance and gave somebody the go-ahead to destroy protected lands. The citizens down there sued, and the Supreme Court said, We hadn't thought about this in about 20-some years, but the legislature has not waived sovereign immunity for equitable actions. If they see fit to do so, that would be the way to go about it. I am concerned, as Representative Oliver is, that we're leaving rules and regs out, because that's what DNR violated, was a rule or reg that dealt with how they issued variances to allow people to have development done. But I would submit to you that we've come a long way. We need to walk, perhaps, before we run. There are other concessions that we've made along the way. It's important to us that our citizens be able to challenge, first, the constitutionality of a law, but also the violation of law by state actors. This bill does both of those very important things, and I believe Chairman Welch has figured out what's possible as opposed to perhaps what we would like to do. And that's sort of the art of what you do as legislators, is sometimes you can't get everything that we would like. There have been a number of good suggestions, but it's a matter of what can we do. And so I would commend the bill in the form of 1929S to you. The last point I would make about what I think we've called the yo-yo provision, and that is the very last part of the bill that the Chairman Welch was talking about a few minutes ago, and that is to limit the ability of a state or other governmental entity from taking multiple appeals up to the Court of Appeals, the Supreme Court, dragging out the litigation. I'm aware of at least one case where, based on three different premises, three different bases of the Georgia Tort Claims Act, where the state took a case up to the appellate courts seeking immunity on three different bases. And there's 13 or 14 of those bases in that law. I guess the parties should be happy they didn't have to go up and down to the Court of Appeals or the Supreme Court 10 more times. This will limit the courts, the governmental entity, appropriately to one bite at that direct appeal. And then with the addition from Chairman Welch, we did not intend to thwart their ability to have that appeal at the conclusion of the case. And so we believe that amendment also is necessary and appropriate. We believe this is important for the people of Georgia to be able to hold their government accountable. As Democrats and Republicans, one thing you all agree is that the citizens ought to have the right to control their government and not allow their government to violate the Constitution or the laws of the state. This bill gives the people a remedy when that does happen, and we would ask you to support it. I appreciate the time. I'd be glad to answer any questions, Mr. Chairman.
Thank you, Mr. Clark. Any questions from members of the committee? Appreciate you being here today. Thank you.
Thank you, Mr. Chairman, members of the committee.
And before we call our next witness, I'll go ahead and acknowledge that we had Judge Hamrick here with us today. Judge, have you ever been to a Judiciary Committee meeting before? Once or twice. Okay. All right. Well, we sure do appreciate you coming out and hanging out with us today. Thank you so much. You doing okay? Robe still fitting well? Good to have you. I don't think we have any other judges here with us today, Judge Hamrick, so it's all on your shoulders to make sure we don't mess up. So we appreciate you. Thank you. Good to see you, sir. All right. Next on our list is Larry Ramsey. Larry, why don't you come on up and please introduce yourself, and we'd be happy to hear from you.
Thank you, Mr. Chairman. Larry Ramsey with ACCG, the County Association. To echo Mr. Clark, my thanks to the Welch Subcommittee and to Chairman Welch for working with us, considering the comments from the local governments. As Mr. Clark said, we haven't gotten everything we asked for, but certainly the subcommittee and Chairman Welch have been very open to considering our concerns and suggestions throughout the process. As I said in subcommittee, there's no good policy reason I can give you to say that a citizen shouldn't have the ability to challenge the constitutionality, for example, of an action at the local government level. So we are certainly not trying to prevent that from happening, as the Supreme Court has said the current state of the law is. A couple of minor comments, though, and really just in light of the changes in the latest sub. As Chairman Welch said, the sovereign immunity goes back to the idea the king can do no wrong, but it's also based on protection of the public purse. And certainly at the local level, that's generally more of a concern than it might be at the state level when you're talking about the cost of litigation. I say that just because in the latest draft, as Chairman Welch had indicated, there's been some changes to the state portion as compared to the local government waiver. And for comparison's sake, and I haven't seen the Welch amendment, but as I understood it, that had carved out the idea of including in here challenges to, for example, state rules and regs because of the APA process that's out there, at least for some state actions. For comparison's sake, the local government waiver is a bit broader. The way the bill is written for the state. So, for example, in lines, I guess through the amendment. Well, give me just a second since I haven't read the revised language.
Go ahead, take your time.
Thank you, Mr. Chairman. Okay, so via the Welsh amendment to this sub, the waiver of sovereign immunity as to the state extends to any claim for declaratory injunctive relief from the enforcement of a state statute on the basis that the statute, on its face or as applied, violates the Constitution of Georgia or of the United States. And I think that's relatively similar to the language that came out of the Court Reform Council. So in that context, we're talking about a waiver of immunity to challenge the constitutionality of a state statute. In the local government section of the bill, the waiver language is a fair bit broader than that. So we're not talking about just the constitutionality of a, say in this case, a local ordinance, but it lines 160 through 163 a fair bit broader, that it would be that a local action had violated the Constitution or a state statute or a rule or regulation or a local ordinance. So for relative comparison, that would be equivalent of including in the state waiver the ability to challenge a violation of a state statute, that the state is not following its own statutes. That, as I read the Welch Amendment, doesn't go that far. Circling back to the idea, I don't know, from my perspective, I can't think of any reason that the waiver for the state should be narrower than the local government one. So just a topic for consideration by the committee on that topic. One other point I'd bring to your attention, I mentioned this to Chairman Welch earlier today when he told me of this, that there's new language at line 168 through 170 from the version that passed out of subcommittee. And this relates to the situation where a local government has put out a project for bid, a contract out for bid or proposals, and the subcommittee heard from the Contractors Association. They're concerned, they want to preserve the right of a losing bidder to challenge the bid process, that the idea that maybe the local government did not follow its own rules. This revised language, this added last sentence at 168 through 170 would indicate that while that option for challenging the bid is open for those 10 days, that the contract that's been awarded could not proceed during those 10 days. And as I mentioned, Chairman Welch, my concern is, as at the state level, certainly local governments have emergency procurements. So, for example, you might have a sinkhole open up in a road, and if you do an emergency procurement, you can't practically wait 10 days to allow that work to commence. So a suggestion that I made Chairman Welch, although I don't have specific wording, is potentially a cross-reference here to the Public Works Construction Law, which is Chapter 90 of Title 36. That sets out the rules for certain contracts at the local government level, the processes that have to be gone through for competition in that context, but it includes an exception for emergencies and defines what an emergency is. So for the committee's consideration, I would ask you to think about the possibility of, if this sentence stays in place with the contract can't go into effect for 10 days, that there be an exception for emergency situations.
What line are you on?
I'm on lines 168 to 170 of the sub.
What LC number do you have there?
This is 1929
Okay.
S.
All right, let me see. Can we give Larry a copy of the sub? Hmm?
That is the right one.
Yours is 19 what?
29.
also here's another copy.
Give me those lines again, Ryan.
Yes, sir, 168 to 170.
So your point being that this could stop an emergency procurement?
As I understand it, Mr. Chairman, if as I read this, if you've had a competitive bid, that to preserve the ability of a losing bidder to be able to challenge that, which was in the prior versions, the new agreement reached with the winning bidder could not go into effect for 10 days. And again, I understand the idea behind it, but there will be those procurements where that would be problematic. And one possible way to remedy that is by cross-reference to the Public Works Construction Law, which does define emergencies, which does allow in that context not using the full-blown Public Works procurement processes
What do you
for
think?
those
What
emergency
do you think about that,
situations.
Mr. Welch?
I've discussed this with Mr. Ramsey, and I think that's fine. I'm working on the language to put that exception into the measure.
Okay, is it fairly easy
Mhm.
addition?
Yes, sir.
Okay. All right. Go ahead, Mr. Ramsey.
Thank you, Mr. Chairman. A couple of other minor comments. I noticed at least a typo on page 8 in lines 229 through 231. I believe those code section references should be to 368050 as opposed to 36850. Again, just a minor typo.
228.
220, yeah, lines 229, 230, and 231.
Yes, sir.
Those code references, I believe, should be 368050. That's
Okay.
the chapter that we're working within
Okay.
here.
All right. Thank you, sir.
And I think that's it, Mr. Chairman. I'm happy to answer any questions the committee may have. Again, my thanks to Chairman Welch and the subcommittee to hearing long hours of testimony and discussions on this topic, and happy to answer any questions.
Any questions of the witness from the committee? Thank you, Larry. We appreciate you being here today. All right. Rushi Patel. Rushi, good to have you today. Please come up and introduce yourself, and we'll be happy to hear from you.
Rishi Patel with the Georgia Municipal Association, and I'll be brief because Mr. Ramsey covered the ground on most of the issues. I really do want to thank Chairman Welch and the subcommittee for working with us throughout this process on little tweaks to the language and keeping us informed as things went along. That really does mean a lot to our organization. I think Mr. Ramsey did hit the nail on the head with the probably largest outstanding issue with that emergency contracting provision, and we do appreciate the opportunity to keep working with Chairman Welch on that issue. And other than that, I'll be glad to take any questions, but appreciate your work.
You don't have any amendments you want to make?
No.
Mr. Ramsey did.
Well, he's smarter than me.
Okay. Well, we appreciate both of y'all coming today. Any questions
Thank
of the witness? Okay. Rushi, thank you so much for coming today. I do not have anyone else signed up on the witness list at this point. And if there is no one else to testify about the bill, we will bring the bill now back to the committee. And at this point, the chair will accept a motion regarding House Bill 311.
Do pass, Mr. Chairman.
Is there a second? There is a motion and a second. Now, discussion. I know, Mr. Welch, you were working on an amendment there that Mr. Ramsey has suggested. Do you need more time to work on that one before we start making changes here?
I do not.
Okay. All right. So let's go ahead and do a couple of items that, as far as the code section change, on page 8 of the bill, lines 229, 230, and 231. It was pointed out to us that that code section, those three code section references should be 3680-50.
As well as 221.
On line 221 as well?
Yes.
Okay, so on line 221, that should be 80. So that's 4 places on line 221, 229, 230, and 231. Is there any objection to making those changes? Hearing none, Mr. Welch seconds it for your record, and it's in. All right, you got those? Okay. All righty. Now, let's see. Mr. Walensky, did you have a question?
Thank you, Chairman. I may have missed it, but do we want to amend line
Pull your microphone over to you there.
It's a long day. Thank you, Chairman.
Well, no, that one, maybe it's the other one.
No, it's on. Just click the button behind it. No, the little toggle button behind it. There you go.
You gotta turn it off and turn it off.
Thank you.
Try now, Mr. Walensky.
Thank you, Chairman. All right.
There we go.
I may have missed it, but I believe we want to amend line 283.
There was some discussion about that earlier. Are you desirous of making an amendment?
Sir, I'm going to pass that. I waive.
Okay, you waive. Number 14, is that you, Mr. Dryer, or is that Mr. Welch?
Yes, Mr. Chair, thank you.
Mm-hmm.
And I am looking at lines 61 and 62 in particular and thinking about the cost burden on a firm my size to have to challenge for injunctive or declaratory relief. And, of course, the specific prohibition on attorney's fees or expenses litigation. Just from my practice, it would make it hard for me to pursue any challenge on the unconstitutional enforcement of any law or any law with that provision in there. And you probably would only get a few interest groups that are well funded that are able to take on this kind of litigation. So just for discussion, and I would be willing to offer an amendment on it as well, if we just simply struck all of line 62 and 61 after the word relief, it would actually provide a little a means of people pursuing justice against the state.
Help me with my memory. Did we not pass one of these sovereign immunity bills before and made it all the way to the governor? And what happened?
We had the first version of this was vetoed by the governor for fear of there being some monetary cost to the treasuries of the state, and that's why this language is in here. This is also the same language that we passed out last year that did not make it through the Senate for the governor's consideration. And that was also to limit and acknowledge that there may, while we want to provide a right to challenge, we also don't want to unduly cost the taxpayers money in defending these challenges beyond a frivolous action.
Sounds like it may be a good discussion for a later day, Mr. Dryer, but to get something on the books and get us heading in the right direction, I would fear that we may threaten a repeat of what had happened before to us, but that's just my thought.
No, I respect that, Mr. Chair. It would be good to get some progress on this issue. Thank
Okay.
you.
Ms. Oliver?
I don't remember the details of Wendell Willard's bill that Governor Deal vetoed in relation to the issue of attorney fees. I've been bringing this issue up with the subcommittee at each line, and I just can't imagine any circumstance. I'm trying to think of any case where the plaintiff prevails in an injunctive and declaratory relief.
Ms. Oliver, I want to make sure your mic is on because I can hear you, but I'm sure everybody else can. Touch your mic, though. Let's see if it's on.
I can't think
There
of
you go.
any other statute where, in a declaratory injunctive action, where the plaintiff prevails, where attorney fees are not awarded. So correct me if I'm wrong about that.
I don't know that they're always awarded, and I think that's left to the discretion of the judge.
That's what I meant. They're not barred by sovereign immunity in any other case.
I would agree with that statement.
This is the reality here for me is somebody who used to do this work a long time ago but has followed it a little bit, is that the Attorney General got a big victory from the Supreme Court and is acting as a defense law firm, which they're absolutely entitled to do, and some would say always entitled to do. But the extent to which we have spent a lot of good time with the interest of the cities and a lot of good time with the interest of the counties, we've spent not enough time on the interest of the citizen who is being not treated appropriately. And the absence of attorney fees seems to be a very significant intent to weaken the citizen's opportunity to come to court with an egregious kind of action.
Mr. Chairman, may I respond?
Please.
For 3 years, we've been working diligently on providing an open door opportunity for citizens to right wrongs that have occurred. And as we sit here today, there is no mechanism other than suing the individual city council members, the individual boards of commissioners, the individual members of the boards of the various state departments. That is your only remedy, unless you want to proceed down the APA. But other than that, we have public servants who are sitting vulnerable to having to pay it under your scenario, pay attorney's fees out of their own pocket against the mortgage of their own home, because there is no insurance coverage presently under either the GERMA situation and I think limited coverage relative to ACCG's coverage. And so the reason why we work so hard with the local governments and to the AG's office is because crafting a bill that provides a window of relief is needed, and secondarily, it does help offset those citizens that want to serve as public servants to know that there's another cause of action that can be brought and not one personally against them individually. But to say that we are not, work diligently to take the interests of the citizens in mind, I'm put back by that statement, because I think that's exactly that's antithetical to exactly this measure. Now, to the issue of attorney's fees, as much as I would agree with you as a practicing lawyer that I would rather have a provision in there that we cannot and that we would not bar attorney's fees. As much as I would love to have that provision in there, I do think that is a poison pill to the ultimate adoption of the measure. And that concerns me greatly. We would sacrifice attorneys making some money over the citizens having a right to the courthouse. I'll forego my attorney's fees to do that.
You do not, though, have an objection to removal of section
I do
5.1.
I do not.
Okay.
Hold on one second.
Then at the appropriate time, Mr. Chairman, I'd like to move to offer an amendment at the appropriate time to remove. I'm trying to figure out whether it's 282 and 283, leaving and then renumbering section 5.2 to be section 5.1.
That would be correct.
I want to. The purpose of the amendment is to change the effective date to 2019 instead of 2020, and I think to accomplish that, I move to amend 1929S by deleting lines 282 and 283 and renumbering 5.2 to be 5.1.
So what you would
Although
do
in
is,
some drafting, I don't think we number the sections if there's only one section. That's what I'm trying to remember.
so
And
you would delete line 282 and 283 and renumber as appropriate.
yes, and what that would mean is a practical effect is that the bill would be implemented upon July 1st, 2019.
There's a motion. Is there a second?
Second.
Discussion. So why did we start with 2020 to begin with?
Andrew.
I'll be honest, on the original version of the bill that came out of subcommittee did not have an effective date assigned to it, so it would have been effective upon the signature of the governor. Mr. Reed may know from his discussions with our Solicitor General.
We didn't have an effective date, so I was asked, do you care what the effective date is? I said, I'll check with the chairman. Didn't get in touch with Chairman Welch. I said, which date do you want? And they said 2020. And I said, okay, I'll put it as a placeholder.
Andrew.
So this Andrew here is
I got approval from an Andrew.
is
I didn't know any of
overriding that Andrew, and I agree with Mary Margaret, Representative Oliver, that the effective date should be as we previously had in the original sub. So I would agree with her. That's which is why I seconded the motion.
Any further discussion? Is there objection to the motion? Hearing none, it's in. All right. Mr. Welch, I think you had another amendment?
Yes, I have an amendment at line, turn to it, at 170. Between the word public and the period, insert the language except for emergency projects as authorized under subsection E of Code Section 36-9-22. Sorry, it's 3691, I think it is. Yes, 91.
You want to repeat that for us?
I
Mr.
will.
Welch?
Line 170, after the word between the word public and the period, insert the language except for emergency projects as authorized under subsection E, so parentheses lowercase e, of Code Section 36-91-22.
Mr. Ramsey, did you hear that?
I did, Mr. Chairman.
Sound right to you?
I think that covers a lot of it. That specifically, my suggestion was reference to the definition because here's my only concern. The Public Works Construction Law, as it's written, only applies to certain contracts of over $100,000. And so there might be other emergency procurements that don't fit the Public Works Construction Law, but nevertheless are emergency. So I don't have a perfect answer, and I think what Chairman Welch did makes sense, but from my perspective, I'm not sure that it captures other non-public works emergencies. So that's why I suggested maybe reference to the definition of emergency without referring to contracts that fall under that public works construction law. I could try to work on any different wording if it's useful to you. I don't
In,
have it right now.
in that case, Mr. Chairman, I can alter the amendment.
Okay.
Except for emergency projects as defined under Code Section 36-91-2.
Okay. Did you get that, Mr. Reed?
Except for emergency projects is defined in Code Section 3691-2.
Yes.
Okay. Chair will second the motion. Is there any discussion? Hearing none. Is there any objection? That one's in. All right. Now, Mr. Welch, you have another amendment.
One last amendment. You have in your folders Welch Amendment to LC 41-19-29S.
And if I'll ask you, Mr. Welch, I think third line in the first section there, declaratory of injunctive relief. Should it be declaratory or injunctive relief?
Yes, that'd be
Okay,
correct.
so we'll assume that the amendment says or, not of, but go ahead and make your amendment.
All right, so the amendment is, there are two well, it's one amendment, but there are two affected parts. Striking lines 46 through 56 and inserting the new section 50-21-51, which I've already described in detail at the beginning of my presentation. And then at line 280, after the words "than once in a case," inserting a new sentence that reads, "The paragraph shall not preclude taking an appeal pursuant to any other paragraph in this subsection."
Okay, and you want to make those two amendments as one amendment?
One amendment, yes, sir.
Okay.
And a motion.
Chair will second that. Is there discussion? Hearing none, all those in favor of the Welch amendment, you got all that? Indicate by saying aye.
Aye.
Any opposed? No. The ayes clearly have it. We now have in front of you House Bill 311 by committee substitute. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The bill moves to rules. Thank you, and we will stand adjourned.